744 times. 744 documents. That's how many documents the South Waikato District Council, my local council, holds that mention me, that are relevant to me, that reference me. I know that because last month I filed an Official Information Act request under our Privacy Act. Here in New Zealand, you can demand that any public agency that holds information on you provides you with a copy of that information. It's your right in law, granted by the Privacy Act 2020. So I invoked my rights under that act to have the local council hand over all the information they held on me, at least all the stuff that they held on me in the last 18 months, because I didn't want to slow the process down. And I got notification back that they hold 744 documents. Seriously, what on earth are they saying about me behind my back? 744 documents. It's a ridiculous number. But they don't want to hand over these documents. They are trying so hard not to hand them over because they know that those documents contain incriminating information. Some of the things they've said about me, they would not like the public to see. Some of the things they've said about me expose them to very real legal liability in a court of law. So what are they doing? Well, I filed my request, my IPP6 request, on the 13th of April. And under the New Zealand Privacy Act, the council had 20 working days to front up with all that information. On the 20th working day, they filed an extension. Now they could do this under the Privacy Act. Where there is extra time required, the body that you've requested the information from can file an extension. So the council said, we need 5 more working days. So they filed an extension of 5 working days, which meant they had a total of 25 working days to provide the information. So that happened on the 14th of May, 20 working days after I filed my application on the 13th of April. That meant the information had to be in my hands by the 20th of May. That's the law. They had their 20 days plus the 5 days that they filed as an extension. On the evening of the 20th of May, I didn't get the information that they were supposed to send me by law. I got a letter saying we're giving ourselves another 5 working days. Well, the reality is they can't actually do that. The Act is very specific. It is very clear. It says that any extensions must be notified within the first 20 working day period after the request is lodged. So the first extension was valid. It was filed on the 20th working day. The second extension was invalid. It was filed on the 25th working day. It fell outside the window of eligibility. But they still filed it, and they still failed to deliver the information they were legally required to deliver to my hands. Several days after that, I got another letter which said, we're going to give ourselves another 15 working days. This would be the third extension, the second unlawful extension, this outside that 20-day initial period. So they are fighting hand and fist not to hand over the information they know that will incriminate them and embarrass them and open them to all manner of legal liabilities in a civil litigation. Now, they've also said that they need the extra time because they need to redact important information such as staff names, which is actually in breach of guidance material provided by the Ombudsman and the Privacy Commission, who have both said that in the case of these privacy requests, staff have no expectation of privacy. When you are employed by a public body and engaged in the work for that public body, you cannot expect to have your name redacted when one of these requests is made. They have no right to redact those names, but they're going to. They believe the law doesn't apply to them, just as they believe they are not bound by the Act's very, very stringent restrictions on the timeframes. They've completely breached those. Now they're saying, we're not going to be bound by the guidance material that says we can't redact this information. We're going to do it anyway. And then, because they are really grasping at straws, they have quoted a section of the Act which allows an extra extension, but only when you are protecting the trade secrets of an independent contractor or third party. Now, I don't know about you, but I can't see how any of my interactions with the council has involved trade secrets. what trade secrets are involved. They've chosen this particular thing because it's the only thing that gives them the right to another extension. But no one in their right mind could believe for one moment that any trade secrets are involved. So they are abusing the Act to try and, again, avoid handing over material to me until I've had a chance to go through it with a fine-tooth comb and remove all the stuff that they think might be incriminating. This is the kind of people I'm dealing with this council. They feel that they're above the law. The law doesn't apply to them. The Privacy Act, which has very strict timelines involved, very strict timeframes for delivery of information for a reason, they think they can flout it. If it wasn't important to restrict the amount of time available to these organisations, then there wouldn't be such very clear definitions in the Act. Council has said, we don't care about the law of the land, we're going to do things our way. Well, unfortunately for the council, that's not acceptable to me, and it's not acceptable to the Privacy Commissioner. I have lodged a formal complaint with the Privacy Commissioner over the actions, the unlawful actions of the council in not meeting the required timeframes and then seeking to withhold information that they are legally obliged to provide. It's going to be an interesting turnout, isn't it? It's going to be very interesting. Now you might wonder, how does the chief executive let them get away with all this law breaking? Well, I'm going to introduce you to the chief executive of the South Waikato District Council. This is her. Her name is Ms. Susan Law. Here she was presenting to obviously a conference or a seminar sometime before she took up the position at our council here. Listen to how proud she is of her actions.
I do recall once closing a hospital in a rural town in Otago, New Zealand, and having met with the community, the police came to me afterwards and said, Susan, I think we'll escort you out of town.
That's right. She's incredibly proud that she upset her community so much that police had to escort her out of town for fear she'd be lynched or something. So that speaks volumes to how much she considers the interest of the communities she serves. Now, during the April meeting of the South Waikato District Council, this same Susan Law, who is Chief Executive of the South Waikato District Council now, had this to say.
In this circumstance, it was what we lawyers called ultra vires.
We lawyers, she said, whilst giving a legal perspective on a matter before the council. One could call that legal advice, legal services. She called herself a lawyer. We lawyers. Unfortunately, that's a breach of the Lawyers and Conveyances Act 2006 here in New Zealand, an act of parliament, another law that says you may not call yourself a lawyer unless you have the right to do so. And the right to do so involves having a current practicing certificate. She's got a law degree. She has a law degree, but that does not make you a lawyer. That just means that you have a law degree. To become a lawyer, you have to go through the New Zealand Law Society. They will check you as a fit and proper person, and you must also do what amounts to an apprenticeship. You must work in a law firm to get the necessary practical experience to become a lawyer. You can't just get a degree and call yourself a lawyer, but that's exactly what it appears Ms. Law has done. Now, all lawyers in New Zealand appear on the register, which is hosted on the Law Society's website. So I went to the Law Society's website, filled out the form with her name. There was no match. It appears that she does not have a current practicing certificate and is ineligible to call herself a lawyer, punishable by a fine of up to $50,000. Perhaps we can see now why the council, under her guidance, feels the laws don't apply to it. Because Ms. Law perhaps feels that the laws don't apply to her. So I've filed an official complaint with the New Zealand Law Society. And the person I spoke to when filing the complaint conceded that based on the evidence I'd presented, it very much appears as if Miss Law has broken the law. But I did a bit more digging because Ms. Law is an interesting character. I looked at her qualifications on LinkedIn. Looking on the LinkedIn qualifications, she obviously has a law degree, Bachelor of Law. She also claims to have an MBA diploma from Stanford, from the Senior Executive Program. Now, I did a bit of Googling, as you would. There doesn't seem to be a Senior Executive Program. There is the Stanford Executive Program, the same acronym, SEP, and there doesn't appear to be an MBA diploma. An MBA is a Master of Business Administration. It's a two-year full-time course, and it's a degree course. It appears to me that Ms. Law has gained one of the certificates offered by the Stanford Executive Program. This may be as little as 6 weeks of full-time attendance or 11 to 16 weeks of online course and you then pay your money and you get a certificate that says I've completed this course. That is so far removed from a Master of Business Administration degree, it's not funny. And nowhere on the SEP, the Stanford Executive Program web pages, does it mention MBA at all. So it would appear to me as if Ms. Law has gained this certificate, but is passing it off as an MBA with the Stanford University connection. Because if you are applying for a job and you claim to have an MBA from Stanford, you are probably going to be able to negotiate a much better remuneration package than if you don't have an MBA from Stanford. So I'm not suggesting she did this because I don't have a copy of her application for the job at the South Waikato District Council. But if she had claimed to have an MBA diploma from Stanford when she applied for that position, and if that was a factor in establishing the amount she got paid, that might be considered to be fraud. Use of a document for pecuniary advantage. And that would be a crime punishable by up to 7 years in prison. Once again, I decided to try and find out for sure. Obviously, I can make mistakes. Anyone makes mistakes. So I thought I will give Ms. Law the opportunity to vindicate herself. So I applied through the Official Information Act, the what's called LGOIMA, Local Government Official Information and Meetings Act. I applied for a copy of her current practicing certificate. If she calls herself a lawyer, she must have one of those, so she must be able to present it when requested. I also applied for a copy of her MBA diploma from Stanford. If she's got that, should be no problem to provide a copy of that. And if she's used that as a part of her job application process, then it should be available. It should be available to anyone that requests it. Now, there's still a week to go until they have to front up with that information. But I'm surprised. I would have thought if someone like Mr. Simpson has come out and levelled these concerns, his opinions about your illegal actions, what he considers to be your illegal actions, you would be pretty quick to knock him down, to make him put egg all over his face, make him look a fool by sending out the copy of your Stanford MBA diploma and sending out a copy of your current lawyer's practicing certificate. Do that in a day, and then Mr. Simpson's left looking like a fool. It's been 3 weeks, I've seen nothing. And I suspect that when the deadline for providing those documents roll round as required by the Act of Parliament, I either will get nothing or I'll be told that they can't provide those on the grounds of privacy. Which is, again, it's not a viable response because Ms. Law advertises her MBA diploma on her LinkedIn page. It's not a secret. There's no privacy involved. She's obviously made that public, so you can't withhold that on the basis of privacy. And if you claim to be a lawyer, you have an obligation to produce a copy of your current practicing certificate when requested to prove you're a lawyer. So if she refuses to provide either of those documents claiming privacy, that is simply an attempt to, in my opinion, an attempt to conceal the real facts, and people will join the dots accordingly. So there you go. I'm not surprised that this council feels that it has a right to break the law with impunity when we have Ms. Law basically pulling the strings at the top. My honest opinion is that Ms. Law has very little regard for the law, and that shows in the way the council responds to lawful requests for information that must be provided in clearly defined timelines under Acts of Parliament. And they have not complied with the law. So I'm going to bring you more on this because there is so much more. Honestly, there's so much more. As I say, I've laid a complaint with the Law Society. I've laid a complaint with the Privacy Commissioner. I'll be laying a complaint with the Ombudsman. And then I will be taking a civil case against this council because it's very clear. Then when someone like just me, little old me, results in 744 communications within council, that they're talking about me behind my back, and a lot of the stuff they're saying probably isn't good. In fact, I've got copies of it. I have friendly people sympathetic to my cause who work in the building and have slipped me some of this stuff, surreptitiously. Now, I'm not going to use anything they've slipped me. That's why I made the Official Information Act request, because I do not want to incriminate my sources. But it does mean that if the council is not forthcoming with all the information they hold on me, then they also fall foul of the Act. It becomes a crime to withhold or deliberately destroy information that should be supplied under the Privacy Act under these requests. So they are between a rock and a hard place. If they choose to withhold stuff they don't want me to see, they run the risk of prosecution under what's called Section 212. But if they do supply it, then it's very, very incriminating, and they must obviously deal with the fallout of that. They picked the wrong guy to piss around with, didn't they? They really did. I think many people I've spoken to have been treated similarly, but have just walked away with their tail between their legs because this is the council, this is the mayor. You know, these are powerful people. You can't mess with them. Yes, you can mess with them. If they mess with you, you can push back. And as I think regular viewers of this channel know, when people try and trample on my rights, when people try and bully me, I don't walk away, I push back. And the harder they push, the harder I push back. And the beauty of it is that when people, hubris is a dangerous thing. When people are overconfident, they think that, you know, their excrement has no odour, they make mistakes. And I believe this council has made some fatal mistakes that are really going to come back to haunt them and cost them a lot of money. Because under the Local Government Act, even our councillors and mayor can be legally liable for damages. They can't be indemnified if they have not acted to ensure that the council as a body has acted within the law and acted prudently and transparently. I think it's pretty clear they haven't acted prudently and they're not acting transparently. Therefore, unless the councillors and mayor step in and demand that the chief executive complies with the law that's currently broken in the form of the Privacy Act, then they become culpable and they become legally liable. And when I sue, the money will, some of the money at least, will come out of their own pockets. Why do they take this risk? What is wrong with these people? I really do not understand it. It beggars belief, but that's where we are right now. As I say, there'll be more coming on this, but I wanted to bring you up to speed because if I didn't have this trail of paperwork, all this information here, you would not believe it. I'm still having trouble believing it, but it's not over yet. It's not over yet. Some of the documents have been provided, but some of them are still outstanding, waiting for this redactions and censorship to protect the trade secrets of external third parties and consultants. Yeah. Anyway, that's it. Thank you for watching. I will make a follow-up when more information becomes available. In the meantime, I'll spot you later.